All right, it looks like we're at time, so let's go ahead and get started. I want to welcome you all to the August 2026 edition of Around the Valuation World. Before we get started with today's webcast, I want to go over a few housekeeping items. First, to obtain CPE credit, you must answer all the poll questions that pop up on your screen during today's webcast. If you have an Around the Valuation World subscription, you'll receive the CPE certificate on your NAHCVA.com portal within 7 to 10 business days. If you have any questions in today's webcast, please use the chat feature or the Q&A feature. Those will be directed to the presenters. If you have any questions about any CVA or any technical questions, please feel free to reach out to me through the chat, and I'll be happy to assist you with that. With the Around the Valuation World and also the Around the Valuation World International webcast, we try to cover all the hot topics in the industry. With the 2 hours that we have, we can't cover all the items that are upcoming. So we do have some links in our materials for you to visit to stay updated within the industry. And this is our Around the Valuation World team. We have Mel and Lena joining us today, along with Janae. And Steve will be joining us a little bit later on. And Ed Mofrad as well. And with that, I'm going to turn the time over to Alina, who will get us started with the presentation today.
Thank you, Shanda. And today we are going to have our normal rundown of the show. We are going to start with Janae Castell. She's going to have the industry headlines, that she go over all those new cases and new information and articles that are very important for us. After that, we're going to have Ed Mofrad, and he's going to be interviewing Nick and Nainesh. You already probably know them. They are our AI experts, and they are going to be talking about your clients are weaponizing AR, and if you are ready. And Michael Kaplan is going to be today our correspondent. He's going to be with our judges. So it's going to be a very interesting session, as always. They are going to be talking about the 10 deadliest mistake of expert witnesses. And we are going to have Stephen White. He's going to be interviewing Danny Hill, and they are going to be talking about sports valuation. So this is kind of new, very specific topic, and I'm pretty sure it's going to be very interesting because as experts, we are always looking to go to industry. People are talking about niches, so I know this is going to be very a new knowledge for a lot of us. And we are going to have Zach Meyers. He's going to be talking about the 2026 NACBA glossary and standards comparison chart update. And at the end, we are going to have our own Mel Abraham, and he's going to be not only the presenter today and doing introductions for sessions, but he's going to be presenting about from transactional to relational, transforming professional services for lasting impact. So now I am going to leave you with Janae, and she's going to be going over the industry headlines. Janae, great having you as always every month.
Wonderful. Great to be here. Thanks so much. Our headlines this month are going to look a little different. So you'll have to reach out and let me know if you like the format, if you dislike it, or if it's something, good once in a while. Oh, doggone, I didn't do my presentation right. I'm sorry. Okay, so the headlines that we're going to cover today are the Big Four valuation leaders point to the need for fair value guidance. This was from the Business Valuation Update. Avoiding double discounting in tiered business structures, which was in the Willamette Perspectives, and complex governance structures in gift and estate tax valuation, which was in Mercer Capital Value Matters. An article from Quick Read, Breakfast Events, Beat the Algorithm in Business Development. And also from BV Wire, BVRP, to discuss final competency brief in a public webinar. All right, so the questions to be answered, issues to be highlighted. The panel for the Big Four points out a need for updated guidance. Should entity level discounts be effectively applied on an asset level basis? Start serving breakfast, or at least coffee. And the Appraisal Foundation will host a public webinar on September 3rd, if you are interested. All right, so the first article from the Big Four, there was a panel, and key points were that customer relationship valuation remains more nuanced and inconsistently applied, an inconsistently applied aspect of fair value work. They noted areas such as AI, ESG, private credit, and complex financial instruments as areas where maybe there need to be improvements or more guidance in the industry. They also, on the customer relationship and attrition and retention, they noted that practitioners may not fully understand when to apply what method for these areas. The panel expressed a need for updated venture capital valuation guidance given the growing complexity of late-stage private company financing structures and the increasing length of time companies remain private before public offerings or exits. To me, this highlights a key aspect of maintaining principles-based standards rather than regulated guidance. Things change. So, what would we do if we were locked into old models of valuing venture capital or old time frames? The exits used to always be, 5 years. That's what they always maybe targeted, maybe 7 years, and now we're lengthening this out. So, what would we do if we were trapped in old models or old guidance? Um, and when we don't foresee that these behaviors may ever change or the markets may ever change. So the panel also noted that over the last decade or so, the profession has developed far more consensus around core methodologies through professional literature, white papers, and valuation standards. But challenges remain wherever, guess what, significant judgment, evolving markets, or incomplete data exist. Okay. Next, there were 2 articles on tiered discounts. Both are easy to download or print and read. For those of you that have a PDF editor, the Mercer newsletter is also easy to highlight and make notes in if you hit the download newsletter button. Okay, so there's a specific way to be able to actually really interact with that format and be able to highlight and such. If that's something that's interesting to you, it is vital to me. So for the first article, tiered discounts are frequently scrutinized by the Internal Revenue Service because of the potential for duplicative or double discounts. Okay. Not surprising, IRS is trying to limit the discounts, right? The Willamette article opens with sage advice to consider the standards and the standard and level of value, and remember that fair market value requires the consideration of hypothetical buyers and sellers. It also suggests an approach to developing the DLOC and DLOM that may be interpreted as applying these discounts individually to underlying interests or assets of the parent company. The article also offers a sampling of tax court cases that have dealt with multi-level or tiered discounts. This may be helpful for you. The article appropriately warns analysts to avoid double dipping on discounts, but makes a statement that, quote, to the extent similar restrictions were incorporated at the lower tier, applying a full DLOC in this case, again, at the upper tier could result in double discounting. Without discussing if the intent is that a restriction on, say, transfer of ownership interest or in one of the underlying or lower tier companies nullifies consideration of a similar transfer restriction or a control restriction in the parent company. So if these 2 companies and layers, they have different the same type of restrictions, can you not consider both of those? Ultimately, I don't think the article is arguing for the application of discounts outright to individual assets, picking some to apply discounts, entity level discounts to, and others to not apply discounts to. It suggests using this analysis to develop a weighted average discount based on the discounts of underlying assets. But in the examples in the article, it's mathematically effectively the same as applying a DLOC and a DLOM to the underlying assets instead of at the interest or entity level. For what it's worth, applying a discount for lack of control only to certain assets did not seem to impress the tax court and Pierce versus Commissioner. The spirit of the article, though, seems to be offering another way to develop and defend a difficult area involving professional judgment. So I would read this and consider whether the preferred analysis can bolster your defense of multi-tier discounts or help you think through what these discounts represent. Okay, so the next article, it was dealing with a similar content. The Mercer Value Matters article urges analysts to start with the governing documents and understand the rights and economics of the subject interest. While the Mercer article says, for example, a veto right may affect control, but only if it applies to decisions that matter economically, and also the rights and economics should be traced through each layer of ownership, it does not go so far as to suggest that discounts of a parent company or a holding company should be applied individually to assets. I appreciated both publications. I appreciated both articles, as well as the authors for contributing to the profession and calling us to think more deeply about the discounts that we apply and how we develop and defend them. Wonderful, well done, John. I don't think that we should ever disparage or scoff at each other for writing such an article for the profession. If you disagree with one or both of these articles, maybe you have further thought-provoking analysis to add to the conversation. Maybe you do this by way of your own future article or presentation, okay? This is definitely an area to think more about, and maybe we can get better as a profession at developing and defending and explaining our discounts. Fair enough? Okay, a little bit lighter article next, but still really a very good article. Lots of details in this. Breakfast Events by Greg Chambers. In the digital age, in-person experiences seem to have even more meaning than before. And the author reminds us that research indicates buyers of professional services like valuations, appreciate more face-to-face contact with the people they work with, not less. Expanding referral sources is not a digital content problem, he says, it's a presence problem. So put on more events. However, he gives advice on events you do not want to host and says the perfect event should be attractive to attend, promise peer interaction, not be salesy, make attendees feel smarter when they walk out of the room, and make us look good without breaking the bank. He says a breakfast event is not a seminar, it's not a CPE course, and it's not a thinly disguised pitch with bagels. So small group in-person breakfast to facilitate conversation rather than being talked at or talked to. He gives some good ways, a good blueprint for contact before and after the event. So I think this is well worth a read. There's a lot in it for you to consider for your practice business development, okay? Next, BVRP, the Appraisal Foundation's BVRP is going to discuss the final competency brief in a public webinar. So if you've been following some of the back and forth on some issues in their brief on hiring a competent appraisal, this should not surprise you that they're hosting a webinar, kind of, I guess, keeping things transparent. So that's very good, very interesting. Some changes that were made in this brief were the language about ideally used PAP should be followed, and then also on the congressional authority to provide appraisal qualifications and standards for all the appraisal disciplines. So interesting turn of events there. If you're interested in that webinar, there is a link on the BB Wire article, as well as the registration for that public webinar. Okay, lightning round. There's a new issue of the Journal of Forensic and Investigative Accounting, articles on AI washing, Benford's Law, and the EY cheating scandal, among others. The link is provided on this slide. I plan to cover some of these articles in the coming months. There was a recent ESOP webinar. So if you're doing ESOPs, there's been a lot going on. There's been a couple court cases. There's been this ESOP webinar on BV resources. So this webinar was highlighted in BVU. It was a dive into the nuances of ESOP valuation report writing. The BVR webinar took place in May, and the link to the recording is there. Pepperdine Private Capital Markets report. If you don't participate in this, you can go look at the results, but I do encourage you to go and do that in the early months of the year. I think it's January through March to participate in that. But you can download that paper, and then also if you want to go see a summary of those results, those are available in the July 15th BB Wire. Okay, AI articles for your practice appeared in the July quick reads. So a guide to what can be uploaded to AI chatbots. This was in July 22nd by Colin Brown, and then also turning past reports into a writing assistant. This was July 8th, again, by Colin Brown. So if those are things that sound interesting to you, I think those are good articles in the quick read to go look at. Always, I can't ever cover everything. There's a lot going on. I'm so glad that Stephen is covering the sports angle on valuation. There was an article in the quick read about special purpose valuations, real estate and business valuation in the intersection. So here's some resources for you, links to download. If you ever have any issues with any of these, please let me know. Questions, concerns, things that you want to see. I would love to hear it. So reach out to me and I will see you next month.
Thanks, Janae. Another great job, and look forward to digging into some of these things further. All right, so on to our next segment, which is with Ed Mofrad. Ed Mofrad's going to spend a bit of time with Nainesh and Nick Mears talking about AI. We're talking about AI and how we use it in our business, but how are our clients going to use it in front of us or against us or with us in the process? So I look forward to it. Ed, I'm going to let you introduce your guests. Thanks for being here again.
Thank you, Mel, for that illustrious introduction. This is Ed Mofrad, CPA, CVA. It gives me pleasure today to once again interview my dear colleagues, Nick and Nainesh. We worked together before and we fit together like hand in glove. Nick Mears is from Caprock Business Consulting of Texas, and Nainesh is from Complete Advisors of New York. And they're talking about a subject that actually sounds scary. Are your clients weaponizing AI? Are you ready? So let's dig into this. Nick, welcome. Nainesh, welcome.
Thank you.
Clients are weaponizing AI. I'm scared. Is that dramatic? Is it actually happening? What's going on? Tell us, please.
No, it's definitely happening. I mean, your clients are no longer just reading your reports. They're running them through artificial intelligence and large language models, and that output is coming straight back into our face. This is no longer just theory. Nainesh and I have been chairs of the NACVA's AI Machine Learning Commission, and everything in this session that we're going to be talking about comes from this field: real engagements, real client emails, real interactions, and real AI critiques. It's an important distinction. This is not just a session whether experts should use AI. Your clients already do. The only question is whether you're ready for what they bring back. So we open up with some polls, and I think you're going to learn some information that you're going to see from that poll that we're going to launch in our session. You're going to see that this is really becoming really routine. And it's more proof and evidence-based, and what I expect to really not be a surprise, but it will be a surprise the first time you see it. And then, Nainesh, what do you think?
Yeah, it's like not only they are using it on our report, but recently I had a client who said, "Oh, I know what documents you will need. I just asked Claude." So it's happening all over, whether you want it or don't want it. So I think what Nick is suggesting is we have to be proactive, and definitely want to share a lot of information that has happened with both of us in the process.
Yeah, the AI phenomenon is happening faster than we can think. It's just every day we wake up to new, developments and news about AI, and a lot of people are scared, quite frankly, and they think their jobs are going to be gone. So what does it actually look like when a client turns AI under experts reports? Like you said, they're already using it. Are they going to use it to penalize us or to trap us? Or yeah, please explain.
Yeah, we're seeing it at every stage. We're seeing it before you're retained. We're seeing it during your engagement. We're seeing it after your report goes out. Each stage has its own specific risks. I had a specific example, and we'll dive into this more in the live presentation, but a banker had introduced me to an owner that was exploring a sale. And before we even spoke, that owner had already run an industry report through AI and walked into the process already anchored on multiples and ranges of multiples. They already had confident tables, bolded conclusions, zero facts about their own company. And that agenda, they already had an agenda, and it arrived on my desk before the engagement letter even went out. It's also happening on the later stages in a litigated manner. An owner had ran my issued report through ChatGPT and came back with a numbered list of really challenging questions. Why'd you use that cap rate? How did you get to that weighting on your WAC? What was your comp weighting? But what about officer comp? How did the K1 treatment affect your cash flows? It really read like a cross-examination outline. And some of it, or a lot of it, really rested on false premises, but it sounded authoritative. And I think that's what also emboldened the client to really dig in. And we talk not only in this session about the experiences, but anyone who's had an opportunity to sit in one of our presentations, we don't just tell you, we don't just throw up a slide. We like to give you a lot of handouts and readouts for how to handle these situations, things that you might be able to consider inside your engagement letters and reports. We want to be able to provide you with some of that specific language, including actual questions that we get, how we responded, and what separates maybe a curious version of a ChatGPT response to a hostile version where they start attacking your work. What are you seeing, Nainesh, in all the stages?
It's funny. I'm answering one email today. This is pre-engagement. We send the engagement letter out, and I got 6 questions back. And one of, all not good question, but nobody asked this before. And I'm pretty sure this came from some form of AI. It doesn't look like AI written. So I'm sure the person knows how to use AI. So it's clean version. But one of the question was, do you have liability insurance? And how much of your liability insurance covers what multiple of fees? Never heard of that question before. It's interesting. I'll answer it. But what has happened is it is becoming so easy to create questions for someone like us, and it creates more work that we need to handle. And I have my ways, and I'm sure Nick has his ways of how to handle this type of situation. And we're going to talk about that as well.
So you got to be able to guide your audience about how they can handle their similar situations.
Yeah, I hope so. That's the intention. We want to, as Nick mentioned, we want to create a path, a framework, a path that people can follow, that they can handle, and how to handle clients' requests even before it's going to arise. You be preemptive rather than reactive.
So can you guys, gentlemen, guide us? Nick has always been going first. Nainesh, let's pick on you first this time. You get a critique. How do you go about it in a professional way? What is the best practice? You get a critique and it's not, all shining stars. How do you go about it?
Nick knows this. I had a client who, it's in the client is in construction industry. So they don't, of course they know numbers, but they don't know numbers the way we know numbers or way we talk about numbers. They don't talk about DLOM and DLOC and, what cost of capital did you use? After submitting a report, I got a 10 question, not cleaned out like the email that I talked about earlier, right out of, Claude or ChatGPT. I knew it's not his question. I knew it was question from an AI tool. The way I handled it was I didn't answer it. I said, let's talk about it. Because you go and answer those 10 questions, it's going to create more questions and it doesn't resolve anything. And I didn't want to tell the client, don't send me AI questions. That's not very nice. So I said, let's talk about this. Never happened. He never called. So that's a different story. But that's one way to handle, but I'm sure Nick has his ways, and we want to explore all other ways possible in the conversation and see how everybody should think about this.
No, I'm on your same page. I think de-escalation is the right way to go about it. And we're all humans. And the problem is when you get a multi-pointed critique, whether they're using industry language that they don't know or know, your lizard brain takes over and you want to fight. So the worst response you could probably have is a point-by-point argument with a machine that's defensive, technical, telling the client that you're either rattled or you're mad, no matter even if the language is coming off nice. The sequence that we really try to teach and instill is, staying calm, treating it as an input, not necessarily an attack. Maybe even I like to ask them, hey, I see what's happening here. I can tell that you're using AI. I think that's great to help you with the process. Can you provide me with a question that you inserted inside there so I can see that whole output in context? Because the context really changes that answer. And a lot of this always depends on your client and who you're working with. You really want to try to respond, of course, in evidence-based language that's really tied to the report or your standards, closing the gap inside that reporting. We try to anchor everything in financial forensics to the Keats model: knowledge, experience, education, training, and skills. That test has never changed. Does our work meet our professional standards? And I really like Nainesh's approach. That's the same approach that I try to adopt. I see these. I think that this is best handled in a question, even if it's from an opposing party, especially if you see it. Say, let's have a conversation. And it's really easy to de-escalate, especially if they're using industry terms and you don't think that maybe they know what they really asked. You can say, well, what did you mean when you wrote this? Well, it's a lot easier if they have, the questions in front of them on a screen on what they want to ask, and they have an outline. But it's very different when you say, well, dive into that a little bit. What specific points would you like to pull out? You talked about the control issues that I had there. Well, which one of the elements of control concerns you the most? Maybe they don't even know the elements of control. There's ways to de-escalate this in a very professional way, and that's what we want to attack.
Okay, and then is there a confidentiality issue involved when they upload your report onto a chatbot or to any other third party? Is this included in your NDA agreement? How do you go about the confidentiality issue? Either one of you gentlemen.
Go ahead, Nainesh.
Absolutely, there's a confidentiality issue. We teach this in our, Nick and I talk about it all the time. Client may not know what becomes a public information and how to protect against that. So if they don't know, we have to teach them. We have to make sure that they understand that putting our report out there on some LLM, which is not protecting your data, can create a lot of issue for the client, and then eventually it might turn out to become an issue for all parties involved. It should be part of engagement letter. It should be part in the report disclosure. But this should be talked about. This should be absolutely a conversation with the client before and during the engagement. Nick?
Yeah, your client may have already uploaded your report. The only question is what settings did they enable or not enable when they did that? So a lot of this just comes up to making sure that they understand that the tools are not inherently private, and privacy is the user's responsibility. It's not the platform's default. And that's one of the things that we'll be able to tell people in one of the, we'll talk about a little bit later, but one of the documents that we'll actually hand out to every one of the attendees who want to attend our program is providing them some tools, some real tools that they can go back to that next engagement or their current engagement, maybe before or even right after they issued their report, and inform their clients, getting ahead of it. We call it taking the sting out of an already issue or a problem that already exists. So there's definitely a confidentiality angle. It's usually where we start all of our AI presentations, making sure they understand that foundation. So it'll be part of this presentation too.
And as a part of AI MLC Commission's work, we have developed a paragraph that one can use. It's not published yet, but it will happen soon. That you can use in your engagement letter or something similar. So that language is coming, at least from what NACWA thinks might be worth using.
So many people listening to this presentation right here and now are thinking, well, that it sounds well and good, but it hasn't really reached our practice yet. What's your response to them? And speaking of that topic, exactly who stands to benefit most by attending your session?
Yeah, I mean, I think that if this hasn't hit your inbox yet, it's just a matter of time. It's just a matter of time before you're going to see it. So I think that if this sounds more abstract and a worry that this is hitting other people, you just haven't had the displeasure of going through this process yet. So feel very fortunate to attend our series where we can show you and provide you with toolkits that you can set inside a folder and forget about it and then wait until it happens. And then I think that for the people who this already has happened to, you'll already have prompts that we're going to give you. We're going to give you not necessarily a prompt that you have to turn to your own ChatGPT. We're going to give you a real handout that you can just save and you can just submit it out every single time. That provides an objective review. I saw in the comments that a client had recently ran a draft evaluation through GPT and asked for errors and inconsistencies and omissions. And that's the exact problem that we see. And as soon as we see that problem, we thought, well, we know this is a problem. How do we fix it? And not just talking about it, we want to fix it. I don't know if it's an inherent man problem about us trying to fix things, but I see a problem and I want to fix it immediately. So Nainesh and I always strategize on how do we fix this problem. So that's what we're going to be presenting to you is one of our fixes to a problem that you can't stop and getting ahead of it.
Nick, you brought up this topic months ago in AI/MLC, but we, as you know, we've been ahead of the curve in terms of understanding what's going on with LLMs and AI tools, and so trying to teach everybody. And now we see this is happening, so we want to make sure that at least our membership knows what is coming down the pike.
Mm-hmm.
Could you, the last couple of minutes that we have left, could you give us some more real life examples of some of the issues you're facing in this regard?
Oh man, there's a lot of problems. There's problems with experts that are also using it who don't understand some of the nuances that we teach in more advanced classes. We have an AI workshop, that's online for 4 days, 4 hours a day for 4 days. We got one that's coming up here pretty soon. We had in-person workshops. We have individual workshops that try to teach people, but if you're not attending one of those workshops, if you're meddling around and you're not looking at sensitivity settings, or maybe you don't understand the difference of how you read a book or a piece of text and how AI actually reads, which is really in batches, and it reads out in all angles, and it's working on guessing that next information. We try to bridge that gap, and if you don't understand the fundamentals of inside that gap and how to work with it, how to test it, critique it, refine it, then you're at risk of relying on something that may be erroneous. How to put checks and balances inside your work. So we're seeing it not only on the client side, we're also seeing it on the expert side too. A lot of this is we're all busy, we're growing. There's more work than I think the industry can handle. There's less entrants that we have. So I think it's just forcing us to be maybe even a little bit more lazy by over relying on the information. So I'm seeing it on the expert side too. Nainesh, is there anything that you're seeing that we haven't already?
Yeah, what one thing I was thinking about when you were talking is the challenges, and this we have to understand and we have to make client understand, is if you throw in one of my report into a chat bot and you say, what's wrong with it? There is no, chatbots are not built to not answer that question. So if you say, what is wrong with this report? It will come back with whatever, 10 points. Doesn't mean those 10 points are correct. It just those 10 points, now you have to talk about it. So that just, that's a challenge we are facing with LLM tools. LLM tools are designed to work with whatever prompt you provide. So prompting makes things, we have to prompt properly.
Let me ask you another question. Can you guys, gentlemen, hear me?
Yes.
Yeah, we can
Okay,
hear.
I had a little technical, I don't know what happened, but for a few minutes I was disconnected. Let's say this is 2031 now, it's 5 years from now. Where do you see this issue? What's your forecast for this AI? I mean, like I said, it's changing by the minute, by the day. Every day when we wake up, there's something new. Where do you see, what's your best forecast? Nick, we'll go with you first.
I tell people all the time, and this is just based on, I keep always going back to the cell phone analogies. My prediction, and I'd love to come back in 5 years and see if I was right. I put a $100 bet that however you're using AI today won't be the same way in 5 years. I think much like those of you who recall MySpace, when you were having to code and build all of that, it's going to be kind of like that. I think that the way that you use prompts, I think that the type of output, I think the ease of information that you're currently getting, my prediction in 5 years is it either will not be accessible because it's going to be so commercialized. You already have IPOs and things going on now. I don't think you're going to get more information. I think you're going to get less. And that's probably going to come with heavier subscriptions, heavier fees, regulations, and licensing. So my big takeaway with AI is get as much knowledge as you possibly can now. use it as hard and fast to as possible to make your practice better. I've been enhancing my models. I've been enhancing my work product. I've been streamlining my process and my practice management to make my work faster, better, and easier to use. So you could kill ChatGPT, Claude, Gemini tomorrow. I won't shed a tear. I've already used it as hard as I can to replicate and make my life easy. And I think that's the big thing is, can you use this in a manner that made what was your life really hard, really easy, even without it?
Nainesh, we're just about out of time, but I don't want to leave without hearing your last word on this. What do you think?
Look, predictions are always, just that. Whatever happens in 5 years down the road, I think we won't be talking about AI. It will be just part of our work, and I think it will do things much better. It's just a question of how best you incorporate that in your practice and how best you convey that to your client. We all are becoming quite efficient, and I think that's just beginning.
You know what that means when Alina comes on with that look? Our time is up. Thank you, gentlemen. It's always a pleasure to work with you. Thank you.
Thank you, Ed.
Thank you, Ed.
Thanks, Ed, Nainesh, and Nick. Always great having you guys. Really quick, I just want to remind everybody about our AI resources and webinar series and our resources on the website. We do have a page that's really dedicated to AI. If you scan that QR code that's on the screen, you'll be directed to a page that has some additional information for you, the additional resources that are available to you. And with that, I'm going to turn it back over to Alina, who will get us started with the next segment.
Thank you, Chanda. And today we are going to have, actually, Michael Kaplan is going to be interviewing our judges today. So they are going to be talking about the 10 deadliest mistake of expert witness. So Kaplan, you can take it from here. Are you there?
Is this better?
Yes,
This
much
should be
better.
better. Yeah, if I turn myself
Great.
on, that's much, much better.
Perfect.
Great. I always enjoy working with our judges. We've done some great programs over the years, and I'm looking forward to many, many more. Today, we are going to be speaking about something that's very near and dear to my heart, something that I've watched very carefully, something that I've been living over the past 50 years, and that is the world of expert witnesses and expert witnesses in the courtroom. It was 50 years ago that I took my first oath on the witness stand as an expert witness. So a lot's happened in that period of time. And I'm just going to jump into it, and I'll bounce it out to our judges. One of the things that I have found, and I find this among very, very active professionals, is they will often place too much reliance on their written report. They will think that just because they wrote a report and just because they put something in that report and just because they handed that report to their retaining counsel and retaining counsel served it on opposing counsel, somewhere along the line, they've gotten the impression, the expert has gotten the impression that when they walk into the courtroom, the judge will have read their report in advance, or the jurors will have read their report in advance. And I've seen witnesses on the witness stand just sitting there wondering why it is they can't run through something quickly when it's something that the trier of fact really needs to have explained in an understandable manner. So I'm going to bounce it out to our judges, and whoever wants to jump in first, and I see a big smile on Judge Driscoll's face. What have you run into relating to experts over-relying on their reports?
So I guess I disagree with the premise about not reading the report. I'm a dweeb. It's a technical legal term. I'm a dweeb, and I love learning something I didn't know before. So if an expert is testifying, assuming that the parties have agreed that the report should go into evidence, which they should, I do skim it. I don't read it in detail. I do skim it, and just to get some grounding. And I've mentioned this before. I think it's so important in an expert report to have an executive summary, 3 to 5 pages at the beginning, which is sort of the, the highlights of whatever's in the report. Because if I'm looking at a 50-page report, I probably am skimming it. And I might be skimming over what you think is so important. You get a chance to bring it to me yet again if you have it in an expert, in an executive summary.
Yeah, so Michael, one of the things I had written down for today was as one of the mistakes is inadequate preparation and unfamiliarity with especially the opposing experts report. You sometimes not that you just overly rely on your own expert report, but that you don't actually know when you get on the witness stand. We're not talking about in your report picking it apart, but we're actually getting onto the witness stand and not having the same familiarity with the opposing report and supporting materials that you do have with your own report. And then you see people get on their heels, even if they have a great expert report, they're on their heels for the other expert. And it just really, it's not a great look. Contrast to that, I've had times where experts know the opposing expert reports so well that when a cross-examination question is asked of them, they know exactly what page and paragraph that issue is in their opposing expert report. And that is very impressive. So it's actually, I'm glad you mentioned it, 'cause it's something I wanted to talk about today with you.
I want to underscore what Judge Adams has just told us. I mean, I have found in my practice that the opposing experts report is a roadmap that assists me not only in understanding the opposing expert's position and how he or she got there, but it helps me put together my rebuttal. It helps me understand where our differences are. Are there differences in evidence, differences in assumptions, differences in methodology? There's so much that one can glean from that. And if I'm on the witness stand and I have familiarity with the opposing expert's report, that familiarity is something that I may want to get into early in my direct testimony. I may, and I likely will have my retaining counsel ask me if I've reviewed that report and address the differences, where we differ and why I'm right and the other expert is wrong. But certainly,
Michael, if I could, first of all, it's good to be back. And I would emphasize what I've emphasized before. The assumption, whether you make it or not, depends on what forum you are addressing. If you're in a mediation, the chances of both reports having been read by any decent mediator are very high, because the mediator probably asked for both of them and got them and has read both of them, and will be asking questions pretty quickly about both of them, may even put them into the as we call it, the tub, and start asking that way. Secondly, in an arbitration, it's almost 100% likely the reports will come in to evidence, and they'll come in preliminarily. And so you can expect that to be a factor. So the forum and the person and the actor and the decision maker are extremely important as to whether you should make that assumption. But either way, you are, as we have noted, and our theme will be, you could very easily be the victim of a negligent or lazy retaining counsel.
that never happens.
And there are a lot of them.
That happens more often than we want it to happen. So
Yes,
If
clarity
you've
on
been doing this,
expectations
by
is
the
another
way, for
thing
I
to
can't
find.
resist, if you've been doing this for 50 years, does that mean your first appearance was when you were 15 years old?
I was 20, I was 27 years, 20,
I was
not
off by
27. I was
roughly a
I was
decade.
29 years old.
Well,
29 years old. Okay. I will be 80 years old on my next birthday. So
Me too.
I'm in good company. I'm in very good company. So there are other things that evolve out of the report. I'm going to ask the judges, have you ever been in a trial? Have you ever had a trial where opposing counsel is cross-examining the expert, cross-examining an expert, and the cross-examination focuses upon disclaimers in the report, focuses upon the limiting conditions in evaluation report? You know,
And
we have not independently verified, turns into you did not bother to independently verify.
that's like a 5 to 10 minute examination. After the 10th question, you didn't do that, you didn't do that, you didn't do that. I got it. I got what you didn't do. It's in your report about what you didn't do. Your disclaimers are in the report. I got it. I think it is an effective cross-examination technique because it does highlight what wasn't done. But some lawyers tend to overplay it. I think that's the problem when it's overplayed.
Do you find
And
a difference?
I would, if you're lucky enough to have Judge Driscoll or somebody who has that level of experience, then the importance of that kind of cross-examination is probably lessened. And even the marketing stuff that can be brought into that kind of cross-examination, again, is recognized by an experienced jurist, arbitrator, or mediator as something that is done. It's out there. It's done for marketing purposes. And while it probably is overdone, it's probably not going to affect affect the judge's ability to discern whether or not the report has any validity. But it'll make a bigger difference with a jury, especially if it's not explained.
I would expect to see it, and I have seen it more often before a jury than before a judge.
Right.
Mm-hmm.
So here's another thing that I've run into, and this is something I used to run into early in my days as an expert. I was doing a lot of work in the family law arena, and I found that many of the experts in that field were kind of I don't want to use the remiss, but relaxed in their process of verifying representations from counsel, representations from counsel's clients, from the litigants. And they will take statements made to them by the litigant or by counsel and incorporate those statements into their reports as if they're verified facts. And then when the opposing expert or opposing counsel attempts to verify, whether it's correct or not, the facts are either not very verifiable or often incorrect. I've usually seen that in the form of too much reliance upon the litigant's representations, especially when the expert spends too much time with the litigant and not enough time developing the evidence based upon the actual fact pattern. Hope that came out right.
That's exactly right, because it leads to the cross-examination. All right, Mr. Expert or Ms. Expert, what you did here was you met with the plaintiff here, and you're retained by the plaintiff, right? And that's where you got your source of the fact here. You didn't independently verify those facts. You met with the plaintiff and the plaintiff only. And I can go on for a little bit just to make the point. And it shows that the expert did not do their homework or is not an expert, but rather an advocate, as we've suggested many times. The expert has to be detached. The expert cannot accept anything at face value without a rigorous examination of those assumptions that are taken at face value.
And that's something we often learn the hard way. I had a case where I was an expert on behalf of a trial lawyer, someone who spent a lot of time in the courtroom, trying cases, presenting evidence, presenting experts and cross-examining experts. And it was a law firm disassociation, a dissolution of a law firm. And there were allegations relating to the American Express bills. And were they one partner's bills, or were they company's bills? Were they personal? Were they business? And the attorney, the client, the litigant, trial attorney, looked at me and he said, Michael, all of the American Express bills that you see going through the business are business related. I have 2 American Express accounts. I keep them separate. I looked at him. I said, Frank, that sounds great. Just give me the American Express bills so I can verify them. Well, you know, Michael, I just moved offices. I just moved from one office to another. I've got a lot of stuff in storage. You know, my partner and I broke up our practice, and, you know, my stuff is not as readily accessible. I called his accountant. The accountant said, yeah, it's not accessible. It's all business. And I kept getting that answer that this American Express bill was separate from the other one. On the second to the last day of the arbitration, opposing counsel came in with 12 months of American Express bills from that one account. And every one of them, every dollar charged on those accounts and paid for by the firm, were personal expenses of this one part. And it was beyond me. And this case was a long time ago. It was probably 30 years ago. It is beyond me that a trial attorney would try to do something like that. You know, it's something that would be understandable if we're dealing with a layperson as a litigant. But when a trial attorney does it, wow.
Which I think brings, again, know your obtaining counsel, know the level of his or her experience, know the level of his or her integrity, and the BS that you know, it's accessible because I moved and all of that. All of that, and again, know who it is you're dealing with. And the expert is, I mean, there's some lawyers who have never had an expert before, and they're going to just think, I just hired an expert that takes care of that. And
they think
they're not, they're out there.
They just wave a magic wand over the expert and think that the expert's going to give him or give her the testimony that they want.
And when the decision goes south, it will be the expert's fault.
Correct.
And now, Michael, I'm curious, knowing what you know now, if you were to be in that situation now, what would you do?
Oh, in that situation with the American Express bills,
yes,
I would insist on seeing them. I would tell him, you know, I don't care how difficult it is to get them. Well, today we could download them from the web, but back then, 30 years ago, they were more difficult to get. Yeah, I would insist upon seeing them. I would tell the guy, look, this is critical evidence. I'm a big believer that documents that should exist do exist. And if the expert is not getting those documents, that's because someone has made the conscious decision to withhold them from the experts. And it takes years to learn this, to really learn it and internalize it and feel it that way. And, you know, candidly, when I look back over the last 50 years, I'm thinking in terms of what I've learned over those 50 years and how my approach to the cases has evolved. But I'm glad you asked me that question.
Wouldn't take 50 years now. All you have to do is listen to an NACFA programs that we put on. You'll pick it up in a couple of years. Right?
We could get to that point a lot easier and a lot sooner. So I know there was mention this morning of the marketing things that you either see in the report or in a CV or in some document that is marketing for the expert. What about the expert who has pretty aggressive ads in legal journals? We will provide you with the analysis, the forensic analysis, guidance and counseling to get your case settled. If the case cannot be settled, we will provide you with the expert testimony that you need to win the case.
That feels risky.
Yep.
That's
Thanks for making me irrelevant.
Right.
If the expert is a lawyer and says that, the expert could be talking to their grievance people.
Right. Well,
Yeah.
the expert is not a lawyer. And
Okay.
what if it's a NACFA member? What if it's a NACFA
Oh,
member?
it wouldn't be. It wouldn't be a
Wouldn't be.
NACFA member.
It would, oh,
No. Then
No,
you'd find them.
today
you'd
it
revoke-
wouldn't be. Today it wouldn't be, but 30 years ago it would. But yeah, I've seen an ad like that, and it's beyond me that someone would put that into an ad that they published in a legal journal, because isn't that just inviting disaster, or certainly in inviting a cloud over their testimony?
You made a promise. You made a promise that this is going to be helpful. Where was I in that equation? You're telling me
Yeah.
you're telling me I'm irrelevant. That's not going to go well.
It's not going to go well for the expert.
Right.
Right.
An experienced, competent lawyer probably doesn't hire somebody that runs an ad like that.
Yeah,
Maybe I'm giving them credit they don't deserve, but I would think that, I certainly wouldn't if I were a potential retaining counsel and hire somebody who promised they could do what had to be done for me to, quote, win.
I think another point that goes a little bit along with that I had in my notes too, Michael, was maybe not so much promising, but being aware of your being contradictory to another case where you've served as an expert, and making sure you have an understanding of the facts of this case, so that when you inevitably get cross-examined about that other case on the stand, which I've seen with some regularity in my court, that you have a very good grasp as to what that other case was about and why that's different than this case. Because it's a pretty powerful cross-examination tool for a lawyer when they say, well, we either your expert report in this other case was excluded. Maybe that's something completely different, but also you seem to come up with a different opinion in this other case, and having a response for that.
And do you believe, or would you advise the expert to be prepared to respond to that, to anticipate the question, and
Yes.
be able to respond in a way where the expert takes control?
Control. Exactly. You're going to get the question, so be prepared for the answer.
Right. What I typically do when I know there's an area that counsel is going to cross-examine me on, and I go through the process of being prepared for precisely for that moment, my response to counsel when he or she asks me the question, the first words out of my mouth are, "I'm glad you asked me that question, counsel." And all of a sudden I put counsel on their heels. And then very, very matter-of-factly, very straightforward, very calmly, I'll explain the difference. I will explain the difference in the position I took way back when, the position I'm taking now, and what are the differences in the case? What are the differences in the fact patterns? What are the differences in the venues? There's so many variables going on. But I've got one more that I would like to bounce out. Same situation. What about the experts who use the same cookie cutter opinion? One of my retaining counsel was telling me about a situation he had with an opposing expert who, in the expert report, and this was, I believe it was a structural engineer or a geologist or someone like that, the guy wrote, "This is the absolute worst case of structural engineering that I have seen in my life." So my retaining counsel went out and he got a number of the guy's prior reports in similar cases, and the same language was in each of the reports. This is the absolute worst case of structural engineering I have ever seen. And the attorney, what he did was he laid out all the 5 reports. Well, was this the worst or was that the worst? Or was this the worst? Or they just keep getting worse every time you take on a new case.
They keep getting worse.
Yeah, they keep getting worse. It's
And why say that? Why not just say perhaps you could say among the worst. That'd be okay.
That would
it's among the worst. Yeah.
That would be a lot easier that would be a lot easier to present how do I say this? This would be a lot easier for the expert to present in the courtroom, the expert to explain, and the expert to defend. And if it wasn't among the worst, they wouldn't have brought him in as an expert.
Right.
Right.
And just like you had talked about documents existing, it's so much easier now for counsel to grab expert reports from the docket, especially if some sort of motion to eliminate has been filed, and they can just search the expert's name and quickly come up with 5 or so other expert reports that this expert has done and see that, oh, they've made the same conclusion in every single case.
Yeah. Cross-examination is much easier than it was back when I was a youngin'.
And a lot more fun.
Yeah.
And a lot more fun.
There's also the insurance industry. Some of them have when you bring up the subject of cookie cutter procedures, they have these the so-called experts, and they're not really. And what their expertise is that I can tell you that this is the established way of valuing this particular problem or this particular issue. It's been used for 30 years. It's the method I used, and it's the only one that is universally accepted. None of that is true. There's a procedure in a lot of insurance contracts for property damage for, say, hurricanes or winds will have a procedure where if they can't agree, you have what's called an umpire gets appointed either by the court or by agreement. And I've had that several times, and I've had more than one insurance claims rep basically, although they say they're not just a claims rep, say what I just said. And I had one where there's a lot of artwork that was involved, and claimant had an expert who was claimed to be and was an expert in the evaluation of certain kinds of paintings. And the expert for the insurance company absolutely said, none of that has anything to do with what we're talking about. Well, this is the only method that can be used and should be used, and should end the debate. It did, but they're not the way he wanted. And that's not rare in that area.
And the experts continue to do this same kind of stuff out there. Certainly the less experienced ones or some of the more gutsy ones. And it keeps us all busy, doesn't it? Chinda has just sent me a notice that we are at the end of this segment. I want to thank all of our judges. You're absolutely great. And I enjoy working with you and am looking forward to our conference presentation on the 2nd of October. And I invite
Same.
everyone to join us.
Same.
Thank you, Michael. Thank you, honorable judges. This is always just a wealth of wisdom. It's not even knowledge, it's wisdom. It's so good. So I appreciate all of you supporting us and supporting the membership. So thank you again. All right, now we're gonna move to our next segment. I'm interested in this. I've never done one of these, so it's going to be interesting to hear. And Stephen White is going to be spending some time with Danny Hill, talking about sports valuations, what it takes, what are the nuances, what are the risks and the things that need to do, maybe expanding your practice a little bit. So, Stephen, you were there?
I am here. Can you hear me?
Yeah, I can hear you, man.
All
I'll
right.
let you take it
How are
away and
things?
introduce your guest.
All right. I am pulling up our slides right now. Just let me know that you can see them. Are we good, Danny?
I can see them. I can see them, yeah.
Okay, perfect. Well, as Mel mentioned, this is going to be an exciting one because of the mere fact that we're going over something that, from my perspective, is something from a personal standpoint as well as from a valuation standpoint, is something that we truly enjoy looking into and reviewing. So we're going to talk about sports valuation, and it looks like my screen has died on me.
Yeah, we just lost the slides.
Yeah. Let's see. Hold on. Let's try it again.
Stephen, I can share if you want.
So, yeah, let's do that. Hold on one second. Can you pull them up, Danny?
There's something on the screen now, Stephen.
Yeah, Stephen, I'm sharing it. So just let me know when you need me to advance the screen, and I'm happy to do that.
Okay, so you can go right to your bio. So we're excited about doing this particular segment because, as a matter of fact, Danny is a professor over at Providence, and more importantly, because I want to spend enough time here really going into what he does as far as his research and how he specializes in sports and in valuation. We just finished the World Cup here in North America, looking at soccer teams, the NFL, the NBA, Major League Baseball, hockey. We hear often, especially as of recent, the number of teams that have been acquired by other entities, private equities, and groups. We start thinking, are these numbers real? Are these valuation numbers real? Or is it just more of a perception hype on what these businesses or sporting teams should be valued as? So today is a great day for us to really dive in. And Danny, we're excited about having you here because you're going to go into an in-depth presentation later on discussing this, but we're just going to hit on a couple of the highlights pertaining to this today. So Danny, welcome to Around the Valuation World.
Thank you for having me, Stephen.
So let's start off with 4 areas that we're going to cover: why sports challenges valuations, where and why traditional methods become unstable, and then we'll talk about the toolkit. So let's start off with sports challenges and valuation. And I know that there's like a lot of misunderstanding when it comes to sports in itself, but then you add in the complications of the valuation. So let's start there.
So one of the things I often go through with my students is when we start looking at traditional business, we start asking simple questions like, what is the best position to be in for an organization? And typically the finance students, the MBA students quickly come down to the idea of being a monopoly. And what we learn from sports economics is that, in fact, would be the worst position to be in. Because if every single person knew what was going to happen and you were the most dominant team, no one would turn up to watch it. So at the very first hurdle of what makes something valuable, it inverts very quickly in the economic perspective in sport. So all of a sudden, we start to realize that sport is not that kind of entity of where we're looking for um, pure dominance. We need competition for it to be the thing that people tune into and want to watch. Why we're sitting there every Sunday watching the NFL, or in England on Saturday, we're watching the Premier League. We're there because of the quintessential we don't know, and we don't want someone to dominate that. And that very first economic hurdle is then what kind of breaks down that traditional way of thinking about valuation and about finance in general. So that's often where we start. And then we then lead into, I think the next slide, Chanda, is where we start looking at what the different aspects then create and what these assumptions then build upon. So traditionally, a firm would be a profit maximizer. Well, again, in sport, that's not the case. Most of the owners are utility maximizers. So they start to buy it for prestige. I think De Morderin always talks about the trophy asset approach, that they're buying it for status, they're buying it for ego reasons. We don't know. Quite common, especially with the billionaires that are emerging, they're buying it because they're fans. They supported the team growing up. They now have excess cash, and obviously excess is a bit of an overstatement. And they now want to buy something that they loved as a child. They're now buying a sports team. And that can move forward. We look at sovereign wealth funds now buying teams as well. Private equity, as you mentioned, Stephen, buying teams as well. So the first question is, they're not profit maximizing owners. They're often utility maximizing owners. So that's one of the first things that starts to change how we view a sporting asset. And then that moves in quite comfortably into rationality. We often hear winning at all costs. Quite big in Europe is club before country, especially in certain parts of the UK where people follow their club more than they'd follow their country. And that irrational behavior under the guise of fandom starts to shape decision making. So when we look at the organization and they're spending tens of millions of dollars on something that most would look at and go, why are you spending that? It's not that they're entirely irrational, but it's their back to that utility. What is the reason? What is the underpinning emotion driving that decision making? And rarely is it rational economic decision making. And then we snowball forward into start, well, let's look at the league structures. Let's start looking at the organization of everything. Competitive market structures is kind of a misnomer in sport because we just look at competitive and we look at structure and think that sports have it. But sports don't operate in a free market. There are significant levels of regulation, spending cap, wage caps, roster sizes that start to constrain what you can actually do as an organization. And then you have ticket pricing restrictions, especially in Europe now with away fans. They're told this is what you can charge to let an away fan into your stadium. So you don't have price control anymore. You're being dictated what you can charge. And then you have revenue sharing, obviously huge in the MLB, where some of the money you generate, you have to hand to another team. So you're essentially strengthening your opponent. We look at the NFL and other parts of North American sports with the draft system. Teams that don't do well get rewarded with earlier draft picks. And one of the things we start looking at in the in-depth session later is winning those draft picks is one thing. Being able to maximize the value that that draft pick gives you is a completely different question. And that's one of the things we're going to in depth in the session afterwards. And teams cannot just join a new league. A team can't say, up with this I shall not put, I'm going to join a new team. There's one NFL, one NBA, there's one MLB. So they can't just leave. They have to stay where they are and compete to that level. And we snowball at market clearing prices. The media often controls the narrative on what things actually sold for and what things are worth. We very rarely see those private details of the deal. And then cash flow and economic decision making. Economic fundamentals is one of the UK, especially the Premier League, provides a great example of cash flows rarely reflect the economics. So the Premier League being the gold standard in global soccer, that is essentially, if you get there, that's the windfall. The season that Burnley was relegated, they made a £28.5 million loss. The following season that they got promoted, so you think, right, they're now back in the big time, they made a £24 million loss. So since the new buyer bought the club in 2020, they've had 1 year of profit, 4 years of loss. And yet they spent most of that time winning and getting into the Premier League. So that economic starts to break down very quickly. And then the one thing that I think that you alluded to at the start, Stephen, about the way the world is moving, when we look at sport, the investor seeking financial return question, that's often a very common assumption we make in valuation. You're buying it because you want to earn something. Now we go all the way back through that chain and we start to then ask, well, let's look at some recent deals. So we look at Saudi Arabia's sovereign wealth fund buying Newcastle United in 2021 for 300 odd million pounds. Newcastle haven't turned a profit since. But in that window of time, Saudi Arabia have managed to land the World Cup in 2034. So was the purchase of Newcastle to buy the club and have a financial return from Newcastle, or was it legitimacy of the Saudi Arabian regime to land the World Cup, showing, look, we're involved in football, we own Newcastle. So when you start looking at the investment in Newcastle from that different lens, and you're looking at the billions of pounds of windfall that will come through from hosting and owning the World Cup for 2034, it's a very different decision making. And then we take the reasons why Newcastle was purchased by Saudi Arabia, and can we apply that to Todd Boehly and Chelsea and Clearlake Capital? No, the reasoning why Todd Boehly bought it probably isn't to land a World Cup in any way, because he can't. So therefore, what's the financial return then for Todd Boehly if the Saudi Arabian one is so different? And in just literally over the weekend, we've seen Amit Bhathia's consortium with Jeff Bezos and Eduardo Saverin's respective investment funds involved in this consortium, buying 30% of Liverpool for $1.9 billion from Fenway. What's the return here? Because Liverpool is not really turning profits, but yet huge players, hugely wealthy people are getting involved. And bringing it back to the US, Josh Kushner's purchase of the LA Lakers, $12.5 billion, which is a 20%-ish premium on what it sold for 14 months ago. And in that window of time, they've lost LeBron James. So their franchise key marquee player has left the organization, and it has gained $2.5 billion in value. Kushner has openly stated that he's buying LA Lakers for a hedge. He doesn't believe that the Lakers and sport will be disrupted by the AI and technology boom, and having it long enough in holding creates a perfect hedge. So all of those factors combined start to really unpack why valuation in sport becomes very difficult.
So I'm glad that's a great segue into that standpoint, because of the mere fact, first of all, that Laker deal happened so quickly. So it makes you wonder, was there something underlining behind that? And you alluded to this as far as a hedge for Kushner. So with all of that being said, how is it then from a valuation standpoint, utilizing our traditional tools that we actually have, knowing the uncertainty that's going on in all sports across the board, whether it's across the pond or here, what would you say and how would you approach this from utilizing the tools that we have?
So as I go into in the in-depth session, which we host later on today, I think there's the toolkit is on a couple of slides time, Chandler, if you want to jump forward. We start to look at, it doesn't necessarily mean at all changing what you do in valuation or how you value. It comes down to those very basics of following the same valuation process, but adding in little steps in between to those steps that give you that reinforcement of understanding about what makes sport so different and capturing the economic difference in the valuation process. So the first thing that we say, I think it's one more slide across, Chandler, is the toolkit. Oh no, this is the kind of what we just already spoke about, but I can build upon this section in regards to what the information that comes forward is extracting the information from the sports team.
Yeah.
So,
Danny, go back to that. Go back one slide. Go back to that other slide again, China. Yeah.
So essentially, this is kind of when we get to the professional sports team level, we start to extract the information. And again, you can break it into, well, what is it we're looking at here? We're looking at the franchise, the financial information bolted to the franchise, the sporting information, and the market information. And what we'll go through more in a lot more depth in the in-depth session is what information do we actually need to extract to develop a valuation? So when we look at this hypothetical team here, they have revenues, they have quite comfortable profits, 68% revenue goes on wages, but they've missed the playoffs in 2 of the previous 3 seasons. There is a new coaching staff, there is significant investment in the playing roster, and 3 elite players are approaching contract renewal. So when we think about simple forecasting evaluation, that becomes very, very messy very, very quickly, because if they're 3 elite players, not only do they then create the most benefits on court performance and therefore revenue, they also then become one of the largest expenses, because they're coming for renewal. They're likely to want to come back and say, we want more money. So until those contracts are signed, we can't start to think about the performance. And if we can't think about the performance, we can't think about the revenue. And that is just one very simple day-to-day problem that will occur when valuing a sports franchise. And that's just looking at the on-court performance. We then don't start to consider the off-court performance when we start thinking about, well, how much should I pay these players? You know, we can have one transaction that looks at a certain player, but if we go down, again, going through history, showing my age, Steve, and we look at Allen Iverson, not many players you could say are comparable to Allen Iverson. So when you're looking at doing a comparable transaction, well, how many Allen Iversons were there? Very few.
Mm-hmm.
So even the depth of market data starts to become very limited. So valuing the player and then valuing his on-court performance that leads to the revenue generation, that's just one small cycle. And then when we think about then, let's look at that over the next 5 to 10 years, it's difficult to do over the next 5 to 6 weeks about how a team's going to do. So in this toolkit that we'll develop in the in-depth session, we'll start to go through what becomes important. And then we start looking at the typical franchise or typical business model and start to extract what pieces of information are actually important that I can solidify my revenue projections, I can solidify my costs, and I can actually solidify what is driving both. Because if I can nail that down, I can come up with a pretty defensible valuation much quicker. If I can't demonstrate where the costs are going to be driven from, or where the performance dip's going to happen and what that performance dip creates in the revenue, it's nearly impossible to come up with a tangible defensible valuation. And I think on the next one slide in front.
Yeah, if you could drop down 2 slides. Yeah.
And this is what we're hoping to cover in the toolkit in the in-depth session. So the first part we start to look at is the structural uncertainty. Now, essentially, that's just looking at why do sports assets behave differently from conventional assets, and ensuring as a valuer we capture what those differences are from a measurement perspective. And then differentiating between temporary volatility, game-by-game performance, and structural uncertainty. So when we think about the revenues in sport, I think the last NFL contract looked at was $480 million per season, and that contract was coming to an end. You need to be able to forecast, well, what is the NFL likely to get in broadcast revenue and what is the distribution model? That then leads into a revenue projection for the broadcast. That allows us to have that better forecasting in the structural aspects and then smoothing over the performance volatility that is very difficult to cover. And then connecting then that sporting performance and the human capital and economic value. How can we look at what a player is likely to do in the next 5 years? What does that then do on the court? What does that then do for revenue? And we start to build back up that valuation picture very, very quickly. One of the key things that I'd hope people take away from the session would be interpreting transactions and comparables in the context of who is buying and why. We alluded to that briefly with the Saudi Arabia example, the Chelsea example, the Kushner example. Why are they buying this? The reason for buying it creates the comparability. Well, comparing what Saudi Arabia paid for Newcastle and what Josh Kushner just paid for the Lakers, are they comparable transactions? Well, of course not. They're different sports with different buyers with different intents. How do we unpack that so in a defensible valuation we can say these transactions are actually similar? We can use the pricing of one to give us an insight into how the other one could be valued. And that allows us to get a more transparent, evidence-based, defensible valuation. So when you're presenting to client, or as we saw from the judges previously, in litigation, we can go all the way back to the start of the economics differences of sport, all the way forward to a defensible valuation that then allows practitioners to say, great, I can actually provide a pretty solid defensible valuation for this organization.
So this is, again, high level stuff that we're going to be going through during the in-depth part of the presentation. Obviously, we're going to look at the valuation methods and the approaches and looking at the different methods that we're actually going to do. But there's one thing, my last question to you before we turn it back over to Mel. We're talking about valuing teams. We understand that you threw out a particular basketball player's name. But who's the best quarterback? How do you value that top quarterback out there?
If you join the in-depth session, we actually started that question precisely that. And again, most of you are sitting there throwing out, oh, it's Brady. Oh, it's going to be Mahomes. We actually tackle that exact question, Steve, and show that it's not as easy as you think to answer that question.
Well, thank you so much, Janae, for this. And China, if you go to the next slide, you would find Danny's all of his contact information there. I encourage all of you to log in later on to listen to this in-depth presentation. It is truly fascinating. Danny, again, thank you so much for your time today.
Thank you for having me, Stephen. Thank you.
Yeah, thank you, Danny and Stephen. And as I mentioned, there is an ABW in-depth session later on today. If you are interested in joining that, as you are joining this segment or this webinar, there is a promo code to get 20% off. So it's ABW-in-depth 20. You'll see that on your screen. And there is a QR code at the bottom. So if you want to register for that, just scan that QR code and register the team. And thank you again, Danny. And thank you again, Stephen, for joining us. And with the ABW at the webinar, we do have the series up until November posted. So on September 21st, we have the anatomy of defensible valuation. In October, it's bridging valuation and forensics when numbers tell a story they shouldn't. And for November, practice keys for successful multidisciplinary valuation engagements. So if you're interested in those, scan that QR code and feel free to register for that. And also just another quick reminder, we have our 2026 Business Valuation Financial Litigation Super Conference coming up in October at the Hyatt Regency in Salt Lake City. We do have a lot of great presentations. There were some sessions that we presented today that talk about some of the presentations that are happening during that conference. So if you are interested, there is that QR card to register. We do have the full conference registration, but then we also have some a la carte registrations as well for if you just want to attend individual sessions. And with that, I turn the time back over to Alina, who will get us started with the next segment.
Thank you, Shanda. So now we are going to have Zach Meyers. He's going to be talking about the 2026 NACVA Glossary and Standard Comparison Chart update. So he's going to discuss and talk about that matter. Zach, great having you today.
Thank you for having me. Let's go ahead and get started. I imagine you guys are going to be controlling the slides, but today we're going to be talking about the NACVA standards comparison charts, as well as the glossaries that the NACVA Standards Board puts out. Now, to be clear, we have two different categories of charts that the Standards Board puts out. So you can go to the next slide, but the first category is the standards comparison charts. Now, those charts take the NACVA professional standards and compare them and provide citation to the other national and international standards used in the valuation profession. This year, we had quite a few changes. The other type of charts that we'll talk about here in a minute is the glossary, and that's a different type of chart that the NACVA Standards Board puts out. But as it relates to the domestic and international charts that the Standards Board puts out, we had quite a few changes this year. Now there's changes every year, and we can't control what the other standard setters do or when they put out their new standards. So it's always sort of a constantly evolving thing. So what the Standards Board, the NACVA Standards Board, attempts to do is update the charts as frequently as possible so that they keep up to pace with the other standard setting bodies. Now this year, there were quite a few changes. IVS in particular, RICS, USPAP actually had some changes as well. And those changes have been reflected in the citations on the NACVA standards comparison charts. I would probably just note that the international chart changed more than the domestic chart, especially with IVS. They changed quite a few things, the structure, the arrangement of their standards, and whenever a standard setter does that, we have to modify our charts. Next slide, please. The second category of charts that the Standards Board puts out is the glossary. So now the glossary, similar to the standards comparison chart, the glossary basically puts out, we have our NACVA, list of terms, but we also compare those to the same or similar terms that are defined by the various standard setting bodies nationally and internationally. This year, there were some changes. Now, these charts will be coming out here, I believe, by conference, but the glossary in particular, IVS was one of the bigger changes again, like with the comparison chart. They had 13 new terms, 3 completely new definitions, about 20 revised definitions, 10 eliminated definitions, and it's like at least about 5 that did not change. Next slide, please. Now, similar to their changes in their standards, the definitions and things, they had quite a few things that are no longer defined, and you got to be careful with that. Now, I know with the glossary and comparing that the various international and national terms that we have, you have to pay attention to whether or not a term drops off, was redefined, or refined. We had quite a few things that really came about when it comes to technological advances, things that maybe weren't defined or needed further defined. Next slide. And really, I guess the 3 categories in IVS in particular, you'll see is that technology and data. They had a couple of things with judgment and risk, which I really liked, as well as review and reliance. So you want to pay attention to those changes on our charts. And one thing I would point out, the standards comparison chart and the glossary, they don't really replace the need to go out to these other professional standards and glossaries that do exist. And you still want to get those and obtain those and review those. But what these charts really are standard setting tools that will help you in your practice. And especially if you have maybe say multiple designations, or you're in court and the opposing expert has different designations, that's where these really, really come in handy. Next slide, please. And in terms of the domestic front, USPAP had a few changes of some of their definitions that you'll note on our glossary comparison charts. They had a few revised definitions, some added definitions, but probably more particularly some retired definitions like assignment elements, misleading, relevant characteristics. These again are good for you to know and be aware of. It doesn't replace the need to obtain these particular standards if they are relevant to you, but these updates will be reflected for USPAP. Go ahead and go to the next slide. I think the next one is Rick's, I think. Yes. So Rick's Red Book, which is an international set of standards, they had more structural changes, which have to be accounted for in our glossary comparison. So, they had some new terms, but more particularly, they had some rewrites, a couple things eliminated. They also have some ESG terms and things that needed to be dealt with. I'm not sure if Rick's changes, I'm not sure what really kind of brought those about. It could have been where Rick's follows IVS and maybe they wanted to account for those different changes, but Rick's is a very strong and long, they've been around for a long time. So it's hard to say why they had the changes that they had, but I really like Rick's professional standards. So I would definitely check their standards out as well as their updated glossary of terms. Next slide. So, it's really important that you guys are aware of like how to get to these charts. I think if you go to NACBA's /standards, I believe, that can take you directly to all these charts. These charts are done for the members. They're done for you and the general public. They come in handy. I use them every day. We've spent a lot of time on these charts. And the standards board, really the 2 main functions other than setting professional standards and maintaining them and making sure they're up to par. These 2 sets of charts our biggest tasks that we have to do on an annual basis. So we put a lot of time into it. We've got some really talented individuals on the standards board that put a lot of time into these things, and it is very hard to keep up with these changes. But it's going to be like this just about every year. I think this year was probably the most changes we've seen, at least since I've been on the standards board. But again, this is not uncommon. There's going to be changes from year to year, and we can't control those other standard setting bodies with the standards they put out or change, or the terms and glossaries that they put out or change. Next slide. So I would just keep that in mind as far as these things are, it's not a lot of like new robust things, but some of these changes, whether it be in the standards comparison charts or the glossary, are sort of kind of happening because of the changes by the other standard setting bodies, but it's really not too substantive as far as the drastic changes. I think some of these changes were brought about by the technological advances. But some of these things just were structural changes that you will see reflected. But again, I highly recommend that you take a look at both the NACVA standards comparison chart as well as our glossary comparison charts, which I think are very valuable to the membership. And if anyone ever has any questions about either of those two charts, which we will be updating and coming out with probably around conference, by all means, reach out to headquarters or myself, and we will try to help you with anything that you have. Thank you.
All right, thanks, Zach. Really quick, we have some extra time, so what I wanted to do, I'm not sure if you can see this, but I'll show you where the charts are that you reference. Let me just stop share real quick, and Zach, if you have anything to add, feel free to. Let's see. All right. There's the website. Let me just open it up all the way. Make sure you're seeing the same thing I am. Yep. So under association on our website, you just go to professional standards and ethics. And a lot of the information that Zach mentioned today is indicated on, or is included on that page, excuse me. So Zach, is there anything you want to add to that or any details?
Well, I would just say this is a really great page landing here. You'll see our professional standards, both the current and the historical standards are going to be there. The comparison charts, which was the first set of charts that I spoke about, that's the professional standards comparison charts. That's that second category. And then the third category there, it says glossary of appraiser evaluation terms. That's the comparison of the different terms that each standard setting board puts out and or defines. So those are some really good resources. We have other resources as well. We have the standards and ethics hotline. You can call with any standards related questions. And if you really need some help, we also have some FAQs, frequently asked questions, which are a compilation of all of the various questions that we get on the standards board. And we try to, find some underlying commonality to create a question that is not necessarily a one size fits all, but describes a situation that the standards themselves may not specifically, explicitly tell you how to do it, but we basically help try to interpret our standards and show you, how to deal with certain situations. So hopefully you guys can utilize these things. I think these are really, really valuable tools. You obviously want to know the professional standards, but anything that we can provide on the standards board that can help you understand and utilize and stay in compliance with the standards, whether they be NACVA or otherwise, that's what we're here for. So.
All right, great. Thank you, Zach.
Thank you.
All right, let me stop sharing. I guess I'll turn it over to Mel now.
Thank you, Chinda. Thank you, Zach, for keeping us up to date and keeping us out of trouble. So I guess we're at the final segment, which is my segment. So rather than me introducing myself, I might as well just start in. In this segment, we're talking about. I'm going to touch on some of the things that I'm going to hit on in my conference presentation in Salt Lake City. I hope that you're all going to be there. And this presentation came about because I've been working with some people to help them build their practice and reflecting back on what now is almost 37 years in practice. And I want to walk through some things and kind of give you some seeds, and we'll go deeper at the conference, because here's what I realized is that you can be right with your stuff, but you can also be forgotten, even though you're right with your content or your report, your valuation. And great work doesn't automatically create a lasting relationship. And what I think has driven my success, my growth over the years, is the relationships that I created with my referral sources, my clients. But early in my career, that wasn't the way it was. I remember finishing a piece of work for a client, and it was good. It was good. The analysis was right. The conclusions were tight. I mean, everything checked. Everything was really, really well done. And you may experience the same thing. And I probably, if I went back and could read my mind, I probably thought, this is so good, they might frame it. And maybe you've done the same thing at times, but nobody has ever framed my financial analysis, my valuation report. You know, I delivered it. I walked them through it. They thanked me. I sent them the invoice. They paid the invoice. And a couple of months later, they hired somebody else. Nothing went wrong. There was no complaint. There was no mistake. There was no problem. They just didn't think of me. And it's truly a polite way of being replaced if you've seen it. And I started to ask myself, how does this happen? Not only how does it happen, how do we stop it from happening? How do you do great work for good people and get the right result and then still become forgettable? And I think our profession trains us extraordinarily well to be right, to be technically right. But being right and being remembered are not the same thing. See, so I think today, especially in the world that we're in, today isn't about becoming just a better CPA or valuation professional. You already know how to do the work. You already know the body of knowledge. You've got that. And it's why some people that are technically excellent in their profession become relationally indispensable. That's what I started to realize, is that it is the relational versus the transactional that we need to think about. Other people that are in there, they may be equally as talented, but they remain transactional. When you remain transactional, that's when all of a sudden you become forgettable. Because once the transaction's over, there's nothing there. I remember early on in my career, I was sending newsletters out. Now, this was back in the day before the internet. I was literally signing newsletters physically, 600 at a time every single month, sending them out. And for 2 years. And this attorney calls me up and he says to me, he says, I have been the victim of your mailings for the last 2 years. Now, when an attorney calls you up and says they've been victimized by you, you think that it's going to be followed by a lawsuit. But the reality was, he says, but now I need your help. And from that point forward, and we're talking about the 90s, every single valuation that came across his desk came to me. No questions, no thoughts, came to me. And I want to challenge all of us to start saying, how many of those relationships have you built? Because we're all good. The competence just gets you qualified. It's no longer the differentiator, and it doesn't even mean that you're going to get chosen. And I remember talking to a business owner, client of mine, talking about the different advisors that he had. And he said, you know what? They're all good. But I just don't know who to call first. And I think we need to think about that. They're all good. And that's what we've spent our careers trying to become. We get so caught up in the technical expertise and the work that we're doing, we become good. We become excellent, better than good. But there's a danger zone there. And when everyone is good, good doesn't determine who gets the call. So something else does. And that's where I want us to start to think, is that what are we doing? We're confusing competence with differentiation. We assume, and I did this long ago too, doing great work long enough, the marketplace will figure it out. And they'll figure out that we're different because we do great work. But it doesn't always happen, especially now. We just talked about the AI, the clients are going to AI, and we've got people out there that think they can do valuations because of AI for $900. That's the environment that we're in. And the technology, they can do the calculations for sure. AI can summarize it for sure. Software can increasingly produce output for us. That the thing that I think we're concerned about is that, does that diminish our expertise? And it doesn't. But it forces, I think, a better question. And that is, where does my real value live? Is it simply in what I produce? The four corners of the report, whether it's a presentation or a PowerPoint or a report, that's a commodity. It's black ink or blue ink or whatever on a page. That's it. Or is the real value what happens because I was actually there with the client, with the attorney, with the case, with the things that we're doing? And I think we need to think about where our value comes from, because I remember with my partners, when I had a full service firm, they kept saying, well, it's hard to sell tax returns and it's hard to sell. And that was the mistake they made, is that I think they believed that they were selling the commodity, the tax returns, the bookkeeping, the accounting. But the real product was something far greater. It was trust. And when we start to understand that, then we don't just rest on the technical expertise, because it's the technical expertise that gets us qualified. It doesn't necessarily get us chosen. And I think that there's three traps that we hit on. And I mentioned one of them. Competence doesn't equal differentiation. And we know this. Good gets you in the game. But when everyone's good, something else has to determine who wins. So competence is the price of admission. It's expected that we know our stuff. It's expected that we can communicate it well. It's expected that we can cite the studies. It isn't the reason, though, that we get remembered. And it's the fact that they remember us, that relationship, that changes the dynamic of your future. I truly do not even have a website that shows that I do valuation anymore, yet I still get the calls, and I will still do multiple six figures, not because of the fact that I'm marketing so much, but because of the relationships that were developed. Trap number two, I think that we need to think about, is value doesn't equate to experienced value. The client needs to experience how we think, not simply get the report. We get all the stuff, we do what we do our mathematical gymnastics, and then we issue a report out and we send an invoice and we're done. To the client, it's got to feel like a one-night stand. Sorry for the analogy, but the reality is that we need to allow the client in to experience our thinking, not just receive our work. Think about two valuation professionals, same quality work. Professional one, here's the report. Let me know if you have any questions, which is what I used to do. Professional number two, before you read this, let me show you the three things that actually matter, the two things that I wouldn't worry about, and maybe the one thing I think you need to consider next. Same underlying work, same expertise, same knowledge, but a very completely different experience. Why? See, clients don't experience our expertise by crawling around inside our heads. Thank God for that. It's a scary neighborhood. But they experience our expertise through the clarity we create for them. Clarity reduces uncertainty. Why do they hire us? Trust, but they also want certainty. Now, we can't promise an outcome, but when there's that trust, they have more certainty. There's a higher probability of hiring you and repeat hires and doing that. And when I help someone see what they couldn't see before, understand what they couldn't understand before, make a decision that they couldn't make before, they don't just experience my work. They experience me as a professional. See, delivering value and having someone experience your value are two different things. Trap number 3, referrals don't equate to reputation. You have referrals, you have recommendations, and you have positioning. There are 3 different starting points. And it's something that I've talked about repeatedly over the years. And most of us are taught, do great work, you'll get referrals. Great, and they're right. But I think we've set the bar too low, especially in today's world. Listen to these 3 statements if I start to do this. 1, I know someone. That is a referral. I know someone. And someone else says, well, you need to talk to them. That is a recommendation. So those are 2 echelons or ways that we get our clients. But then there's another one where someone says, they're the one you need to go to. That's positioning. When someone turns around and says, there isn't even a short list, there is only one to go to, that's positioning. That transcends your marketing, transcends everything that you're doing. Those aren't 3 versions of the same thing. They're 3 different starting positions. The referral, if you think about it, it transfers awareness. It lets them know you even exist. The recommendation, that transfers confidence when they say, here's one. But positioning, that transfers preference. At the positioning, you're no longer trying to prove that you actually belong in the conversation. You're just confirming what they already believe. See, that's when you start moving from the one that's the hunter to the one who's being hunted. And so when you start to understand that, what the best do differently is they make a couple of shifts. And I have a framework that I'm going to teach in detail, a couple of frameworks that I'm going to teach in detail at the conference, but 3 shifts that you can start to look at today that separate transactional professionals from relational professionals. And you kind of look at it and say, well, what are they? Well, I've come down to shift number 1 is execution versus interpretation. They don't simply deliver their work. They help the clients understand what it means. And when they understand what it means, it opens up a different kind of conversation, a different level of trust, a depth of believability. Now, I understand that we need to keep our objectivity through the whole thing. But that doesn't mean that we can't help them understand what we're doing, why we're doing it, and what it means in their world. Shift number 2 is going from answering to anticipating. Those that create relationships, they don't wait for the next question. They see around the corners, they see what's going on. They start to ask the questions, and they actually bring the questions to the client that the client didn't even know to ask. When we start to bring that awareness and shine that light, we bring in more certainty into their world, more trust into the relationship. And then shift number 3, shifting from private value to visible thinking. And this one makes, I think, some professionals uncomfortable, because somebody says, this idea of personal brand. And half the CPAs in the room, when I've done this, they break out in hives when I start to say personal brand. But I'm not talking about being an influencer. I'm not talking about you getting on TikTok and Instagram, although we have some of our folks that are doing that. I'm talking about something bigger. Having people know you for what you know. Every single person that is on this session that's going to be at the conference, I consider an expert. You know stuff. You have knowledge. You have stuff that you can do for people. You can transform them. The question isn't what you know. There's an enormous difference between knowing something and being known for something. And being known for something, that's when your reputation starts to compound. Your thinking travels into rooms that you're actually not in. Clients start describing how you think. People recommend your perspective and not just your services. The fact that you're positioned and you're known for what you know puts you in the top levels when they start to do searches, when they try to research, because that topic brings you to the top of the page. And when the right problem arises, all of a sudden, you're the only one. You're the only one. So this is what we're going to cover in much more detail, building something together in that full session. I'm going to talk about this framework that I call the impact ladder and the 4 levels of doing things: do the work, guide the work, shape the outcome, be known for the thinking. Those 4 levels of outcome. I've got another trust paradigm that I'm going to teach you. I want to unpack all of it, but I can't unpack all of it now. I know. And you're going, well, that's obnoxious. I'd love to get all of it. Well, let's get into the conference and we'll do it, because between now and our session, I actually want you to start thinking about something. I want you to think about one question, and that is, where do I spend most of my professional life? Not where could I operate? Not where does my title say I should operate? But where do my client relationships say I operate? If we talk to a client, what do they say? Do they primarily hire you to do the work? Or do they ask you to guide the work? Do they bring you in early enough to shape the outcome? Or am I actually known for the thinking that I have? See, when we're together, we're going to unpack how you climb that ladder. How do you create a client experience that makes your value no longer intangible, but tangible? How can they experience it? How do you move from answering questions to helping your clients ask better ones? And how do you deepen the relationships so referrals move from referrals to recommendations, and recommendations become your positioning? How do you build a personal brand without becoming a personal brand or an influencer? And how do you create a practice where your relationships and your reputation bring you more opportunities, increasing opportunities, higher value opportunities to you? That's what we're going to do. That's what the session's about. I hope that you'll take some of the shifts from here, start asking the questions, and start looking at the things that you're doing in your practice to say, am I being transactional or am I being relational? Because it's the relational thing that's going to give you longevity, not only in your career, but it's going to elevate your ability to bill, your billable rates, and the things that you do. So I look forward to seeing y'all in Salt Lake City, or getting a chance to go deeper on these things, and I can't wait to have you all there. All right. That's what I have for you, and I think we've got the final polling question out, and then we'll close this out. Before the conference next in the end of October, we have one more ABW coming back to us on September 21st, 2026. If you want to be a guest on on that cast or any of our future AVWs, do me a favor, reach out to Chinda, let them know, bring the topics. We're always looking for new people, new ideas, new thoughts. And if you want to make sure that you're getting the continuing education, reach out to headquarters and let them know. Make sure you're registered for AVW and answer all the poll questions. Until then, thanks for being here, and I can't wait to see you all back on September 21st and at the conference in Salt Lake City. Cheers for now.